In the popular game show, Who Wants to Be a Millionaire, that ran for about 20 years, one of the things that you could do as a contestant is phone a friend. So, you get stumped on one of these questions. You have an opportunity to reach out to a pre-assigned friend to be able to help you in time of need. Now, the key is you had to set that up in advance. If they didn't pick up the phone when you gave them a call when the game show was going, you didn't get the help. So setting things up in advance was really important in that, because it might mean you're either a millionaire or you're not based on the outcome there. It's a little bit similar in terms of being able to get help when you need it via a power of attorney document. So that's what we're going to talk about today.
Thanks for joining us for this financial planning overview video about powers of attorney and living wills. Spencer, as we think about power of attorney and living wills, we're going to do more of a question and answer, but start us off, frame us out. What are we going to be thinking about today?
Yeah, so power of attorney generally is one of those most important estate planning documents, and you're basically naming an agent to act on your behalf during your lifetime. Oftentimes we talk about a durable power of attorney because it's durable in the sense that when you're incapacitated, it still functions. It still names that agent as one who can act on your behalf, which is obviously very important. Now, a power of attorney, once you pass away, is no longer in force. At that point in time, we switch over, and the person that's coordinating your financial matters is the executor or the personal representative of your estate. So that's an important distinction. The other thing that we'd say is there's different types of powers of attorney that we'll get into today. One is related to property or financial matters, typically that's drawn up. A second might be for healthcare and kind of end-of-life wishes, who makes those decisions, and if you're incapacitated, helps to work with the physicians. A final document would be that living will or an advanced directive of sorts that would try to make sure that everybody's on the same page of what your intent is should certain medical things happen towards the end of your life, whether you want to be resuscitated, all kinds of things like that.
So what can a power of attorney be used for?
So a power of attorney, again, we've got those two different types, and we'll focus in on the property side of things here. Really, anything that you can do in terms of making decisions on your financial matters, you can name a power of attorney, an agent, who will be able to do that on your behalf. And this, usually when you sign it, it goes right into force. So, if you name a spouse or you name a loved one, they're able to make decisions on your behalf, and they really run the gamut. So they could make decisions based on, the tax that's withheld for distributions from an account. They can make decisions based on how an account is allocated, make decisions how they're going to set up distributions in an account, how they're going to even change beneficiaries. So the power of attorney has to specify, that document has to specify the actual powers, because every one of them is a little bit different. We have some powers of attorney that are drafted where a agent can change a beneficiary designation. In some circumstances, that is not a power that is given. So generally speaking, you can act and do the things that a person would need to do to manage their financial matters. And usually it's a durable power of attorney. And that would mean, again, that when you're incapacitated, that person especially can step in and then be able to manage your financial matters on your behalf.
So explain more of that durable word. What does that mean?
So at the point of incapacity, if there is not a clause in there that makes the power of attorney durable, then the power of attorney, the document, could cease to be functioning. So we want to make sure that that's durable in most circumstances. Now, in some circumstances, there's actually what's known as a springing power of attorney, which would mean that the power of attorney does not spring into action until an incapacity. Now, the challenge here is that if you choose to go that path, typically you've got to have one or more physicians that say that indeed a person is incapacitated, which can be difficult to set up the physician's appointments, get all of that lined out. There can be a significant lag time for you to be able to make decisions after that person is incapacitated, which can be challenging for loved ones.
So then I presume when you're signing a power of attorney, you probably need to be competent of who you're choosing, and you need to be of sound mind. Is that correct?
Yeah, so you have to be of sound mind, just as you pointed out. If you have dementia, if your faculties are failing, then that could be contested. So we had an example where we actually had what we would call dueling powers of attorney. We had one that was signed when client was in full mind. She named her second husband as the power of attorney, as her agent, her attorney, in fact. But her children from a first marriage did not like second husband. So when he was in a situation where he was not present with her, they took her and had her sign a second power of attorney, giving them privileges, giving them rights as agent. And then the difficulties began because financial institutions then said, well, which one is right? So if we come back to it, the person has to be of sound mind to be able to sign that. And then they can always revoke it if they need to. So oftentimes someone will say, well, this person's not the right agent anymore because they moved out of town or they're aging and they're not the person that I really want to name. So you can always revoke it, but you need to be of sound mind to do so.
So who can you sign as a power of attorney?
Well, typically our recommendation is someone that you trust very significantly.
It's probably really important.
I think you've got to be actually at least age 18 to serve as an agent. But generally speaking, you want someone who's wise, who you can trust. The law, as we'll talk about, defines an agent with a fiduciary responsibility. It says that they have to put your best interests first. What you want to make sure, though, is that you have enough trust to know that they would do that regardless of what the law says. The law does hold them to that standard, so there is a bit of protection. But we want to say, you really want to trust the person that you name as agent, whether that be on the property side or the healthcare side of things.
So Spencer, you've gone over a lot of things so far. You've talked about what can we do, how do we get these powers in place. There's a lot of leeway. What can't an attorney in fact or a power of attorney do?
Attorney in fact can't testify in court, for instance, for an experience that you had. So you couldn't, say, witness a vehicle accident and then send your agent to testify, on your behalf. So there are things that you can't have your power of attorney do. They can't create or revoke a will or codicil to a will. That's another piece. Now, it's interesting because they can name a beneficiary, oftentimes to an account, if you give them that, but they can't write a will for you or a codicil. So an important difference there.
All right, so I'm an attorney. Let's say I'm an attorney, in fact. What do I do when something needs to be done?
Right. Really important. So typically, what you end up doing, most of the time that we see these play out with our clients at least, there's an incapacity or there's a person that's moving towards mental incapacity, and an attorney, in fact, is named, and we take that power of attorney document and we present it to a financial institution. So it might be a custodian or a bank or some other institution. That institution will typically have requirements that another document be signed. There might be an affidavit that needs to be signed, or they may push back and say, no, this doesn't meet our standards. Now, if it doesn't meet their particular standards, what we oftentimes need to do is reach out to the attorney for the attorney to then give a call to that financial institution. Because power of attorney completely drafted appropriately should be valid and it should be received by those institutions. But you can imagine that the institutions sometimes have this concern about liability, and you're just presenting them a piece of paper. They don't know if it's valid or if the signature was forged or something like that. So they're skeptical to begin with. But usually if you have an attorney get involved, and particularly an attorney that's reputable and one that maybe they've done some business with over time or they've seen clients use over time, then oftentimes that kind of helps get them over the hump in being able to deal with that. But typically, again, there's some additional documents and you may have to present identification there as well to serve as the agent.
Spencer, you mentioned sometimes financial institutions will need extra information. Sometimes that's like an affidavit. But what even is an affidavit?
It's just a sworn written statement. It basically says, I am the person who I'm saying that I am indeed named as the agent. Here is the power of attorney. There's different pieces to that. Sometimes it's boilerplate type of information that needs to be filled in and then you sign. There's a lot of different ways that can go. But they, again, just want to cover themselves to say, hey, we've done our due diligence. We're not being frivolous in just allowing account access to someone other than the client.
Right. So let's say we've gone through all these circumstances. We've gotten a lawyer involved. We've sent the affidavit. What if that financial institution continues to refuse to do what the powers of attorney have asked?
Well, and that's where we would say lean on the counsel of the attorney. Because, again, we want to state clearly, we're not attorneys. We're not going to draft a power of attorney document for a client. But these are the things that we've seen that we are concerned, that we want to make sure that if you're listening to this video, watching this video, that you know that it's an important document and you know some of the lay of the land here. But at the end of the day, everything that we say, you need to run through the counsel of an attorney, lean on your attorney's input in terms of working with any institution that pushes back.
So Spencer, let's shift over to this idea of being a fiduciary. You mentioned it earlier that powers of attorney can be fiduciaries. What does that mean?
You boil it down and it means you have to act in the best interest of the person that you're representing. So you can't make decisions, for instance, that are self-serving to give you some kind of an advantage, or your friend over, here, give, your buddy John an advantage in dealing with the person that you're supposed to be representing and taking care of there. So that's really what a fiduciary means. There's a lot that's to that. What you should know as well, though, that if you make some decisions and they're good decisions, they're based on best practices and investments go down, typically you're not going to be held liable for that because, again, you walk through a process where, say, you diversify the portfolio. You understood the risk that your person that you're representing would take, that would be reasonable, that would kind of balance a need for income, but also preservation of capital. When you've thought through these things, then you can even engage a professional, whether that be a financial professional or whether that be an attorney, and bring them into the loop and pay them for that counsel. When you've done what you need to do in terms of due diligence, even if the outcomes are not as you would hope in the end, again, if the process has been strong, then typically you're not putting yourself in a bad situation.
So essentially, if I put everything as a power of attorney into a leveraged cryptocurrency, then I might be held liable.
You might be.
But if I diversify broadly, then maybe we're in a better state because we've said we're acting in the best interest. Leveraged cryptocurrencies probably are not in the best interest of someone who is mentally incapacitated.
Right. So we think back to 2022, stocks and bonds were both down over 10%. Let's just say that you held a sufficient amount in cash and you had a diversified portfolio that matched the income needs of a client, even if those accounts went down in 2022. The court is generally going to look at things and say, well, if you diversified, if you did everything that you could in your power to make prudent decisions, you're not going to be held liable. But again, that's something to have a conversation with your attorney about.
Right. Okay, so let's talk about this idea of, when we think about people that are in a place where they need a power of attorney to be acting as that fiduciary on their behalf. Oftentimes people want to see investments go up, investments go down, but you have to balance that with current income needs. So when we're thinking about that, can a power of attorney sacrifice long-term gain for immediate income needs?
And that's something that they can. It's something that, again, looking at the particular situation, if you are power of attorney, and for instance, if you're agent and you have a client who's incapacitated that has a very long potential life expectancy, you might say, well, we need to get some growth, from these resources over time. So that may be a circumstance that allows you to take a little bit more risk. If you're power of attorney for someone who's very concerned about running out of money and he or she is in their late 90s, then you might need to be much more conservative and have the vast bulk of those resources in money market CDs and short-term bonds, something like that. So it's really specific to the particular situation in terms of how you might allocate a portfolio.
So can you be too cautious, though, when you're allocating a portfolio?
You certainly could. So if you took on no risk, if you had everything in a savings account in the bank and had we're content to say we're going to have a 0% rate of return if the savings account wasn't paying you anything. And we know that we've got to get some gains, we've got to get some income there over time to be able to sustain the standard of living for that person. Maybe they're healthcare needs as well, then that would not necessarily be a prudent decision just to have everything in cash. So we can be too conservative. We can also be too aggressive as fiduciaries there.
All right, Spencer, we're going to shift again from financial now to healthcare matters. So when we think about powers of attorney for healthcare, what considerations do we need to be aware of?
Well, first, you might be naming different agents for financial matters in healthcare. This often happens for us. We have maybe one child who does better with the financial side of things, another child who knows the medical space, or maybe is just more empathetic to mom or dad, named as a contingent agent there, or a successor agent, I should say. So it can be different people, and what you want to do there is you want to specify the amount of latitude that you're giving that person. Can they make decisions based on end-of-life care? Do you want that to be driven more by your living will? How much latitude are you giving them in all sorts of different matters there? So that's something that you really want to craft with your attorney to know what level of decision-making that person can have and where you want to say, no, this is off the table. I know that in these circumstances, A, B, and C, I want these decisions to be made.
Okay. So you mentioned living will. Talk a little bit more about that. What is a living will?
Living will basically presents you with a number of different questions of what happens if, for instance, physicians diagnose that you are in a vegetative state and that you have no potential chance to recover. Do you want to continue to receive sustenance via IVs and other means? It might be a decision based on whether you want to be resuscitated or not in particular circumstances. So there's a lot of those very end-of-life type of decisions. And what this can help you do, it can give confidence to your loved ones that they're making the decision that you wanted them to make. Because there's nothing like having 2 or 3 opinions out there, and maybe even a physician's opinion that might differ. And then you've got an argument and different people saying, well, what would mom or dad have wanted here? Instead, if you've specified that, then it kind of anchors the conversation to say, well, this is actually what was the desire.
Okay, so we've gone over financial matters. We've gone over generally what are powers of attorney. We've gone over healthcare. What are some last things that we need to know about all of these documents, the living will, before we close out today?
Well, we come back to a couple different things. As you think about powers of attorney, you want to think about who you're naming as an agent, as we've talked about, a successor agent, at least one successor agent, because if your agent is not able to act, you want to name that successor who would be able to step in. But you also want to really think about the latitude that you're giving that person. Typically, we want to have a person, again, who is high trust there, who has the technical capability, whether that be on the financial or the healthcare side of things, to make good decisions and decisions that would be aligned with you. But you also want to think about some of those edge case decisions. Do you want to give them a capacity to open a new account, to change the beneficiary designations? These kinds of different pieces that can be quite helpful for an agent if they have them, if you have complete trust in them, because sometimes they can move some things around that actually position your estate better. But you need to have a really high level of trust if you go that path where they can make decisions, for instance, with gifts to charitable institutions or to family members, because sometimes it can make more sense to make some gifts prior to a client passing away or rearranging things. But again, if you're giving them the latitude to make gifts to family members or friends, you also introduce some potential that things don't go out exactly as you want them, because you're giving them more choices.
Spencer, that's been really helpful walking us through these powers of attorney, all these different decisions. We hope you enjoyed this video. And again, Spencer and I, we're not attorneys. We can't draft any of these documents. We'll review them with you, but we can't make any changes. We can talk with your attorneys if you're a client of ours. But again, we're not doing any of this on your behalf. So take it with a grain of salt, talk to your attorney, and we'll see you next time.
If you like these financial planning videos, please share with a friend. And if you have questions,
Go to our website at SeriousRetirement.com. This content was provided by Retirement Planning Services. We are located in Knoxville, Tennessee. You can visit our website at SeriousRetirement.com. The information in this recording is intended for general educational and informational purposes only and should not be construed as investment advisory, financial planning, legal, tax, or other professional advice based on your specific situation. Please consult with your professional advisor before taking any action based on its contents. Advisory services offered through Retirement Planning Services, LLC.